Court has recognized that there is a vital relationship between the freedom to associate and privacy in one's association. Compelled disclosure of affiliation with groups engaged in advocacy may constitute a restraint on that freedom of association. The issue before the court today is whether the Maine Commission on Governmental Ethics and Election Practices, when they denied the petitions to vacate or modify the subpoenas, erred, either as an abuse of discretion, an error of law, or their decision was not supported by the evidence.
The National Organization for Marriage funneled $1.9 million raised from its donors to the Stand for Marriage Maine PAC to promote passage of the People's Veto referendum in 2009. NOM asserts that none of this $1.9 million was raised for the purpose of promoting that People's Veto referendum. The Commission's investigation seeks to test that assertion in order to determine whether NOM has to file as a ballot question committee or BQC.
The donors in their solicitations, and why can't you get that from NOM without having to question the donors?
Well, Your Honor, that's asking, restricting us to only one party's version of the conversation. And NOM has a clear policy that they say they do not allow their donors to earmark. So what they tell us is, we may have talked about a lot of things, but we don't allow our donors to earmark.
So the Commission wants to test the credibility of NOM's response by speaking directly to the people to whom NOM spoke.
The Supreme Court has said that you have a right to privacy in your association. So it's the compelled disclosure of these names by donors from around the country.
So, Ms. Phillips, let me press you on this. The Commission has a responsibility to assure that your organization registered under the appropriate laws. You have said, trust us. We did not do anything that would require us to register in this fashion. And then what you have said is, you're simply going to have to rely on our word that we did nothing that would have triggered this particular statute. That's not how litigation works in the United States. They have a right to test the credibility of the person saying, trust us. Of course we would comply. How can they do that without asking the donors what was the communication from NOM?
Well, they have the text of the communications themselves because this is an objective test.
But many of the communications were, in fact, oral.
That is correct.
So isn't it perfectly appropriate for the Commission to say, we want to ask the donor, what were you asked to do?